maybe in that answer you could discuss and look at what is the primary issue that you attribute to the continuing kind of problems with vertical enforcement?
The continuing problems, currently there's the vacancy issue, and that has been a problem that started before transition, and it was where we were required at the time to hire candidates off of SROA mandated hiring lists. And so many of those people after transition were offered their jobs back at the California Department of Corrections and the Department of Justice for higher paying wages. And so those people, many of those people have left back to those original jobs. And so there has been some vacancies, and it's going to take some time to rehire those individuals and replace them and do backgrounds and get them into working again. So we are expeditiously doing hiring panels to get those staff on, putting several people in background at once and trying to get that problem corrected. However, there is the pay inequities that the director mentioned. And we have a retention pay proposal that we've pushed forward, and the department is supporting to try and take care of those issues. And I'd like to echo that this is the correct place for those types of investigations. They are very complex. The staff is very knowledgeable. It's a high level of expertise, and they already have working relationships with many of the deputy attorney generals that are involved. It is something that actually worked very well. The transition went very smoothly. However, there are some challenges. Vacancies has been one of them. But there's also been many benefits. Benefits including standardized law enforcement training for all of that staff, the new vertical enforcement protocol and vertical enforcement training, parallel prosecution guidelines for criminal and administrative investigations, cloud-based document sharing. It's been helpful for our staff as well as the Attorney General staff, and then electronic case binders for investigative materials also been very helpful. So there has been some challenges. We're working through those, and but there's also been some benefits, and I think it is a new program. We're 18 months in, and I think that we're doing incredibly well. The new vertical enforcement manual is only 8 months old, and it is more streamlined. It's a smaller document, and it standardizes the timelines. It also provides the ability to, if there's a disagreement between an attorney general or staff, there's a resolution process built into that. And we're doing more training and more coordinating and meeting with the Attorney General's office on a regular basis. So it's a work in progress. There has been some benefits, but there has been some challenges also, and we're moving through those. Well,
and it's good to hear, because you indicated that obviously it's all about the working relationships, and yes, we had heard that there have been problems between your office and the Attorney General's office, and so you've indicated that you've done some kind of workarounds and ways of making the communication work in an efficient, productive, and healthy manner, yes, so that relationship will be successful. So we hope that continues, because that's the only way this vertical enforcement will work, is if that relationship can succeed in that way. So did you have Mr. Director? Okay, very good. Another question along that, could you explain the parallel proceedings protocol and yes, how that's moving here, and is it a viable option to help VE succeed? And I guess the question that I'd like to get the answer to is, when is the decision made who takes over a case when it's going from administrative to criminal, and how is that handled? It's actually very simple. It's based on the facts of the case. When that complaint comes in, when that information comes in, on its face, if it's criminal in nature, if it's a serious, egregious manner that is a felony offense, that's obviously criminal in nature, and that's something that we're going to pursue from the start.
And through this, I know there was some discussion about it, and so beginning December 8th, we started meeting with the Attorney General's office to work through that very issue. And so what we have developed is parallel prosecution guidelines to take care of that issue so that the case, when it comes in, it's simultaneously given to the district attorney's office to handle that criminal part of the investigation and refer to the AG's office at the same time so public protection can be achieved. So they could actually take any necessary action against that license so there's no time delays. So we've been working together. We've taken that draft policy and asked for the Attorney General's comments. They've made edits. We've incorporated those edits, and we're still working on that document. We've also asked for the medical board's review of that document, and we've been having ongoing meetings to get that policy into play. And it should be in play by the end of the week or early next week.
Oh, very good. And perhaps, Kimberly, if you'd like to make some comments about how you see things going?
Absolutely. Well, good morning.
Good morning.
Chairs Hill and Bonilla and committee members and staff. In regards to the transition of the investigators to the Department of Consumer Affairs, I couldn't agree more with my colleagues to my left that I believe it was a very smooth transition. I think the board and the department held meetings to where we met with staff to really help that transition for the actual personnel, the staff themselves, and so I think that went really well. We actually believe that it's too early to really identify the impact of the transition to the Department of Consumer Affairs and think that more time and data would be necessary in order to determine its impact. In regards to the vertical enforcement model itself, as you all know, you've all received a copy of our report that was done on March 1st of this year. And we do believe that the vertical enforcement model needs to continue. But we did have 4 recommendations that are listed in that report to the legislature, and we are hopeful that those 4 items are actually looked at and that there are some changes that can be made. And I can go over those if you'd like, or I would leave it to questions from the committee.
Sure, if you want to mention them,
Okay, all right.
that'd be great.
Well, the first one that the board determined was that in order to provide a true team and utilize the expertise brought to the team by both investigators and the deputy attorneys general, the board would recommend changes to the language that is found in the Government Code Section 12529.6B. The board also believes that language needs to be amended in the same section to allow staff within the board's offices to consult with the Attorney General's office on cases, including those cases that actually are investigated by our non-sworn staff that are still part of the medical board. The board also believes an amendment needs to be changed to Government Code Section 12529.6E to remove the medical board and put in the Department of Consumer Affairs due to the transition of the investigators. And then lastly, the board does believe that the Department of Consumer Affairs and the Attorney General's office need to utilize the new manual as that has been described previously, and to continue to develop strategies and protocols to assist the investigators and the attorneys to improve the vertical enforcement model. And those were our 4 recommendations.
Very good. That's great. Thank you. Questions? Very good. Yes, Senator Wachowski.
We just got your letter to the governor on the first report for the administrative hearings, right, on the Office of Administrative Hearings, and you have lots of charts in here. I have a question about the mandatory settlement conference that's being used in the contractors state licensing board, because if I'm reading the chart right, there's a contractor license board have like 974 cases, but the average time that they're, like in Sacramento, is 7 days. And I know that there's a footnote on the osteopathic medical board in Los Angeles. It seems like they only had 2 cases, but it averaged 141 days. And I'm wondering if you can share with us some of the benefits that you had with the mandatory settlement conferences. It seems like it's speedy, but I know there's other legal issues we want to talk about, and whether that's you're suggesting that may be applicable in some of these other boards and commissions to get to resolution?
Yes, this is Zach Morzini. I'm happy to address that. It's kind of a pilot project, given the complexity of a lot of these cases. There's a lot of expert witnesses involved in some of these CSLB cases. So this is basically like a pilot project where the Attorney General's office basically requests that before we even set this thing for hearing, can we get before one of your ALJs and try to settle these cases? We've had great success with it. And so, yes, it's something that's fairly new that we've been doing. I dropped a footnote on that stat because what it does is it skews the average on how many days it takes my office to set a case for hearing. Because when we set it for a mandatory settlement conference, that's not a hearing. We don't set it for hearing till that process is unsuccessful. But we're very happy with the program. I believe the Attorney General's office is, DCA is, with the program.
So what, I guess you're going to be coming back well, this may be coming back on a yearly basis, the Office
Correct.
of Administrative Hearings, because it would be, we're always looking, or I'm always looking for alternative dispute resolutions and ways to speed up the courts. And we're looking at alternative courts, whether they're drug courts or veterans courts, and there's a whole variety. And it seems like this is an element, a flavor of that conflict resolution that may be beneficial to the board.
Yes, we are happy to continue working with our partners here in the process. There is obviously one downside. Those cases that don't ultimately settle, what we've just done now is we've drug out the time frame, the case life at OAH. And so it's going to be a matter of figuring out what cases this is going to be most successful in as we go down that road towards implementation, because each case is different ultimately.
Our conflict-driven society.
Senator, from the department standpoint, we welcome the thinking outside the box from Office of Administrative Hearings and Attorney General's office. This is indicative to other pilot projects that the Attorney General's office has partnered with us on, and we see great benefits in our higher volume boards and bureaus, where if you settle or if you force resolution, it really brings down the workload and allows the staff to focus that bandwidth on the more complex cases. So I welcome ideas, I welcome collaboration and continued thought through this process. So.
And I don't want to miss my chance to also chime in and say that the Attorney General also believes that these pilot projects are very successful so far, and I think that if anything, it just shows that with creativity we can come up with a lot of ways to improve efficiencies in what is otherwise a very complex process.
Very good. Thank you. Seeing no other questions, we can excuse the panel, except for you, Mr. Director. You're stuck for the day, I think. But thank you very much. And now I'd like to invite Mr. Ed Howard, who represents the Center for Public Interest Law, to make some comments, I think, regarding the vertical prosecution model, if you would be kind enough, Mr. Howard. Thank you. Thank you again for all of you for coming today and for your testimony. Mr. Howard, good morning.
Good morning, Mr. Chairman, Mr. Chairman, Ms. Chairwoman, Ed Howard with the Center for Public Interest Law. Very briefly, I think what you heard was good news about an important public program. Briefly, the way to underscore how important vertical enforcement is to remind the legislature why it's had an unwavering commitment to its existence and proper implementation for now nearly 10 years. And that is to remind us about what happened before vertical enforcement. Before vertical enforcement, there was something called the handoff model, where once a complaint was assigned to investigation, the complaint would go to the investigator would work up the case without the benefit of collaboration with counsel in complete isolation, notwithstanding the fact that, of course, it's counsel at the end of the day that has to have admissible evidence and has to prosecute the case using the second highest burden of proof in the law, not reasonable doubt, but clear and convincing evidence. One of the things that was persuasive to the legislature at the time was the understanding that not only is this counterintuitive when it comes to working up a case in an adversarial setting to be presented with a respondent who's represented by counsel, not only is it counterintuitive, literally nobody else does it that way. As an attorney in private practice, I will tell you that I use investigators. It would have been astonishing for me simply to assign the investigator a complaint and have the investigator work without collaborating with me on figuring out exactly what kind of evidence we needed and how it should be obtained to ensure its admissibility and persuasiveness. And the same is true with the investigator. So that doesn't happen in the private sector. It doesn't happen anywhere in the public sector where we're dealing with comparably complex cases. That's the reason why the legislature hasn't insisted on vertical enforcement, and that's the reason why the good people who you just heard testify have been so diligent and thorough and passionate about its appropriate implementation. And with that, just thank the chairs for allowing me the opportunity to speak very briefly about that and
Thank you, Mr.
entertain any
Howard.
questions you may have, of course.
Thank you for the good news and for your support of the process. It's very encouraging.
Thank you.
Thank you. Now I'd like to open this to public comment on this portion of the hearing. If anyone has any comments on the areas that we've discussed already based on the Department of Consumer Affairs. Anyone wishing to? Okay, very good. Well, now we'd like to invite Wayne Bell, Commissioner for the Bureau of Real Estate, to join the Director to provide an overview of the Bureau and to discuss issues that were raised in the background paper. Mr. Bell, good morning.
Good morning.
And welcome to you.
Good morning. My name is Wayne Bell. I'm the Real Estate Commissioner and the Chief Officer of the Bureau of Real Estate. I've been in those roles for over 3 years and have worked at the Bureau and its predecessor, the Department of Real Estate, since March 2006, when I started with the department as its Chief Counsel. I want to thank Chair Hill, Chair Bonilla, and members of the Senate Committee on Business, Professions, and Economic Development, and of the Assembly Committee on Business and Professions for the invitation to appear today. I appreciate this opportunity to represent the Bureau of Real Estate and its 320-plus employees in the oversight process and to respond to the several issues and recommendations that have been offered by the staff of the committees. I have prepared and want to share with you a brief overview of the Bureau of Real Estate, which I might refer to as the Bureau or CalBRE, including its history, functions, activities, who it licenses, and the number of its licensees, and a brief description of its budget. Real estate licensing in California began in 1917 with an act which created the Office of Real Estate Commissioner. 2 years later, in 1919, a revised act to define real estate brokers and salespersons to provide for the regulation, supervision, and licensing of such brokers and salespersons, to create a real estate department and the Office of Real Estate Commissioner, and to provide for the enforcement of that act, was approved by then Governor William Stevens on May 27, 1919, and went into effect on July 27, 1919. CalBRE has been in existence in one form or another since that July of 1919. Since July 1, 2013, the Bureau has operated under the umbrella of the California Department of Consumer Affairs. CalBRE is, as was the department before it, the state agency that, one, licenses, regulates, and disciplines real estate agents and those residential mortgage loan originators who have obtained an endorsement to their real estate license. Two, investigates and commences action against unlicensed persons acting as or in the capacity of real estate licensees. Three, enforces the statutory laws known as the Subdivided Lands Act relative to the qualification of offerings for the initial public sale, lease, or financing of new residential subdivision properties through the issuance of public reports. Four, oversees the Vacation Ownership and Timeshare Act. Five, administers a consumer recovery account for victims of licensees. And six, otherwise safeguards and promotes the public interest and consumer protection in real estate matters. I am proud of the work that the Bureau performs in order to champion public protection in real estate. CalBRE has, as of yesterday, March 8th, a total licensee population of 405,911, including 23,827 mortgage loan originator endorsements to real estate licenses. The Bureau's total net budget for fiscal year 2015 to 2016 is $51,272,000, and the proposed total net budget for the next fiscal year, 2016 to 2017 is $53,945,000. Since 2011, the last time the real estate licensing and regulation was before you, the real estate and mortgage markets have improved. As described in the background paper, those improved markets have brought expected challenges for CalBRE's licensing and subdivisions programs. As a result of the amelioration of the markets, we have seen a decrease in the volume of complaints associated with the housing and mortgage meltdown, but an attendant increase in applications for real estate licenses and for the issuance of public reports under the Subdivided Lands Act. The last oversight hearing resulted in several measures that improved CalBRE's ability to meet its mission. We believe the public and the industry have benefited from the requirements relating to self-reporting by licensees when they face law enforcement actions. Also, the flexibility of CalBRE's disciplinary spectrum was improved by the addition of citation and fine powers, allowing us to efficiently deal with low-risk and low-impact violations of the real estate law. We also appreciate the ability to seek our enforcement costs when engaged in administrative discipline, another result of the 2011 oversight hearing. And as with many other licensing bodies, we believe the public protection was well served in 2012 when licensees were barred from including gag orders within civil settlements. Our new strategic plan is reaching its final stage. The draft plan is the result of much planning and the gathering of information and input from a diverse array of stakeholders as well as CalBRE employees. The draft with objectives was completed internally in December of 2015. And since then, my executive staff has been discussing the plan and their program areas to develop the action steps necessary to finalize the strategic plan. In this process, we are looking at specific tasks to make sure we have appropriate, responsible persons and due dates to achieve each objective, and to determine whether there are gaps that also need to be addressed by the strategic plan. Although we originally expected to have a final plan this month, we are now targeting June 1, 2016 as the completion date. Certain things incorporated in the plan that I am looking forward to involve our recognition of some existing strengths of CalBRE and working to maximize those strengths. For example, we have a wonderful and dedicated internal IT staff and IT system, and we plan to work to expand our use of information technology to create greater excellence and efficiency for our licensing process, for our subdivisions unit, and to facilitate the Bureau's operations. Another thing we want to do is to enhance the collaboration between our in-house enforcement, legal, and audit units to maximize CalBRE's enforcement efforts. With regard to this point, we want to go further with the use of those resources as a team performing complex vertical investigations and prosecutions. I would now like to respond to the specific questions the committees have asked me to address. Issue number 3 addresses public outreach performed by CalBRE and suggests recreating an advisory committee to serve this purpose. Our current public outreach is active and extensive. As commissioner, I go, as does the Bureau and a number of its employees, to great lengths to speak to and receive input from the general public. For example, public outreach efforts since just January of 2014 have included representatives of CalBRE, including myself, speaking at over 150 community forums, legislative town halls, and including town halls hosted by members of your committees. For instance, I spoke at a town hall in Santa Clara for then Assembly member, now Senator Wajkowski, and Assembly members Dodd and Baker. And we have presented at public partner and local realtor association events throughout California. At many of these speaking engagements, CalBRE representatives were joined by representatives from the United States Attorney's Office, District Attorney's Office, City Attorney's Office, Department of Business Oversight, Contractors License Board, California State Bar, and local police and sheriff's offices. These engagements were well attended, attracting people from all walks of life, including seniors, veterans, licensees, recent immigrants, homeowners facing foreclosure, and victims of real estate fraud. A number of these engagements features presentations in Spanish, Chinese, and Russian. These engagements were in addition to the 3 open forums that CalBRE presents at California Association of Realtor functions each year. Our forums are open to the public, and we provide notice of the forums on our website. These events are also well attended and have included realtors, non-realtor licensees, and members of the public and the media. In addition to CalBRE's speaking engagements, the Bureau representatives regularly write articles about the real estate industry and real estate issues, which are of interest to licensees and the public. Many of these articles are published in CalBRE's Real Estate Bulletin, which CalBRE sends electronically via RSS feed, mails via request, and makes available to its licensees and the general public on its website. Since January 2014, CalBRE representatives have written or updated over 75 articles covering various real estate subject matters, including preventing real estate fraud, maintaining broker trust accounts, enrolling in continuing education, seeking recovery from the consumer recovery account, filing real estate complaints, and using the services of mortgage loan brokers. Many of these articles have been translated into foreign languages, including Spanish and Chinese. I believe an advisory committee is not needed at this time because CalBRE's current outreach efforts, as outlined above, give the public, licensees, and consumers of real estate license services opportunities to hear from the Bureau and to offer input on CalBRE's activities, policies, and proposals. Issues number 4 and 7 address CalBRE's relationship with the California Department of Consumer Affairs, or DCA. As the committees are well aware, the Governor's Reorganization Plan number 2 of 2012 converted the Department of Real Estate to a bureau and moved it under the umbrella of DCA. While much of the Bureau's operations remain unaffected by this change, principally due to the fact that the Bureau has its own management team and utilizes its own resources for licensing, enforcement, legal, audits, and information technology, the Bureau has experienced some inefficiencies in other areas under DCA. The inefficiencies have occurred primarily in the areas of human resources, contract management, fiscal, and regulations. It takes longer to fill vacancies, contract with and pay vendors, reimburse employees for travel, and promulgate regulations. There has been some improvement in the administrative processes of DCA since the appointment of Director Kadani and his Chief Deputy, Tracy Ryan, and we continue to have an open dialogue. The department, DCA, charges CalBRE a pro rata, which is projected to be approximately $5.2 million during fiscal year 2016 to 2017. In exchange for this payment, DCA provides CalBRE with services for fiscal, including development of CalBRE's budgets, business services, human resources, training, contracting, publications design, editing, and completion, public information liaison, legislative, strategic planning, and some investigative work through DCA's Division of Investigation. As you have identified, the pro rata has doubled since fiscal year 2013-2014. My understanding from the department is that during that time, we paid less as part of the transitioning of services. The current rate, I'm told, reflects the same methodology as used with other programs, but I will have to defer to the department for further details. On issue number 12, pertaining to license suspension, the committees requested additional information on the purpose of Section 10177B of the California Real Estate Law and how a potential change to that authority might affect the Bureau. Section 10177B provides one of the principal grounds upon which the Bureau can impose discipline when a crime has been committed by a licensee. Among other things, it provides in relevant part that the Bureau can suspend or revoke the license of a real estate licensee if that licensee has, quote, entered a plea of guilty or nolo contendere to a felony or a crime substantially related to the activities of the real estate licensure, close quote. However, the law does limit the Bureau's use of a guilty plea, requiring that CalBRE wait to suspend or revoke the license until the end of the licensee's criminal due process. The Bureau has seen instances where major criminal cases involving real estate fraud have taken years to work their way through the federal and state criminal courts. In these cases, we have seen licensees who were defendants plead guilty early in the process as part of a plea bargain that furthers the prosecution of all other defendants. Those guilty pleas may not result in a conviction for months, if not years, and the case against the other defendants proceeds. As presently drafted, that guilty licensee who has entered his or her own voluntary knowing plea may continue to practice real estate. In considering the proposal, the committees will need to weigh the need for consumer protection against the rights of licensees to due process. Issue number 15 in the background paper asks about the consumer's consumer recovery account, which is funded from a portion of fees paid by licensees. The purpose of the recovery account is to provide for limited reimbursement to consumers for losses sustained in connection with real estate licensed activities because of the intentional fraud and dishonesty of licensed brokers or salespersons upon the satisfaction of certain requirements contained in California Business and Professions Code Section 10471. Since its inception in 1964, over 50 years ago, more than 4,500 applications have been filed, and the Bureau has paid more than $54 million to consumers. Current law requires that the recovery account balance cannot exceed $3.5 million as of June 30 of any fiscal year. When money is transferred from the account, it goes into the real estate fund. Since the late 1980s, the law has also provided two options to preclude fund shortages. The commissioner may transfer funds from the real estate fund into the recovery account. And, excuse me while I turn this page here. So the commissioner may transfer funds from the real estate fund into the recovery account, and there may be a temporary fee increase imposed if the account dips below $200,000 at the end of a fiscal year. Because of the present level of payouts resulting from the after effects of the housing and mortgage meltdown, a transfer of funds from the recovery account to the real estate fund is unlikely to be triggered. In closing, I thank you, the members of the Senate and Assembly committees, for your invitation to this oversight hearing, for your support of the California Bureau of Real Estate, and I look forward to working with you. I'm happy to answer any questions you may have.
Good. Thank you very much, Mr. Bell. Would you like to ask?
Sure.
Madam Chair?